The Second Amendment enshrines the right to bear arms. Today we'll be talking about what exactly arms means under the Second Amendment. Hello and welcome to Talks on Law. I'm Joel Cohen. Today we're joined remotely by Professor Jake Charles, a professor of constitutional law at Pepperdine Law School. Professor Charles, let's talk about arms.
All right, let's do it.
The right to bear arms, we all think of guns, but what does it actually mean under the Second Amendment?
Yeah, so the Second Amendment says arms, not firearms. You wouldn't notice that from our public and popular discourse about the Second Amendment. And even many court cases kind of confuse the notion of arms and equate arms with firearms. But in fact, the Supreme Court, in its Heller decision in 2008, said that the term is quite broad, that it extends to all weapons that constitute bearable arms, kind of circular definition of arms. But the court said weapons of offense or defense. So presumptively, a large category of weapons fall within the definition of arms. And Professor Eric Rubin at SMU Law School has a really good law review article that talks about the gun centricity of Second Amendment doctrine and how that warps our understanding of what weapons are covered, because most of the cases are, as you suggest, about guns themselves. And the Supreme Court has not really said much more about what particular weapons are encompassed within that broad definition, but it's given kind of two flip sides of the same coin about what weapons are in and what weapons are out. So what weapons are in is what's called the common use test. And this is a test that the Supreme Court hinted at, but has been developed in lower courts. And what that test says is weapons that are in common use by law-abiding citizens for lawful purposes get Second Amendment protection. So weapons that are not in common use by law-abiding citizens for lawful purposes presumptively don't have constitutional protection.
Interesting. So here are we talking about, I'm imagining, bow and arrows that a hunter might use, or a pocket knife that may be common?
Sure, yeah. There have been cases about certain kind of knives and knife restrictions on the lengths of knives, and some courts have said those are unconstitutional. Same thing with nunchucks. There have been nunchucks cases where courts have said some kind of the regulations of those are unconstitutional. The flip side.
So there are places where nunchucks are illegal.
There was a New York case. I don't know if they were illegal, but they were certainly regulated in certain ways, or at least certain type of nunchucks. So there was a New York case. Yeah, absolutely. And so the flip side, though, is that weapons that are dangerous and unusual do not get protection. So even if you might think, oh, well, that's fairly common, if it's dangerous and unusual, usually meaning if it's mostly used by those who are intent on doing harm unlawfully, then they're not going to be protected. And what the paradigmatic weapon there is a machine gun. So machine guns, the Supreme Court has said, can be banned. In Heller, it said M16s and the like can be banned. And so machine guns, even if they were, say, frequently used by sports shooters, they would still not get constitutional protection because they're dangerous and they're unusual.
Does the dangerous and unusual mean there can be restrictions on guns that are dangerous and guns that are unusual, or they must be both dangerous and unusual?
This is an interesting debate because there's been an actual discussion over the and versus the or. Some of the historical sources the Supreme Court cited used an or. So Blackstone, for example, he says dangerous or unusual weapons. The Supreme Court in Heller said dangerous and unusual weapons. And then the Supreme Court suggested that it's a conjunctive test, that it has to be dangerous and unusual. And one of the reasons for that is that kind of guns are recognized as inherently dangerous. There's kind of no objection to recognizing guns as a dangerous weapon. In fact, that's part of their appeal, is that they're dangerous weapons. And so how to interpret that phrase, right, is the Supreme Court hasn't said, and kind of courts are all over the map. Some suggestions are that weapons that are unusually dangerous are the kinds of weapons that fall outside the scope of the Second Amendment. But one thing we know for sure, at least we have hints of what the Supreme Court has said, is that weapons that are very commonly used and mostly used by law-abiding citizens for lawful purposes, those kind of weapons are weapons that do get presumptive coverage under the Second Amendment.
As a non-expert, it seems to me that unusually dangerous should be what we cared more about, not about how common or unusual the weapon was.
I think that's right. I think one of the problems is establishing a baseline there because, weapons that might be unusually dangerous in 1791, right? A AR-15 probably would have been considered unusually dangerous in 1791 when there weren't the repeating rifles that we saw later in the next century. And so weapons that they might have thought would be unusually dangerous today are actually commonplace. So one question for this test is establishing a baseline.
That's another point, that it's a moving benchmark. So it may be unusually dangerous at a given time, but not in another.
Yes, I think that's right.
Why don't we take a look at some case law? What have we seen in recent times where courts have been asked to interpret what is an arm under the Second Amendment?
Sure. So one of the most consequential decisions was a decision by the Massachusetts High Court that said stun guns are not protected arms under the Second Amendment. And it used kind of a curious test by saying, well, these weren't common in 1791, therefore they don't get protection today. And the Supreme Court, in what's called a per curiam opinion, this is an unsigned opinion, so we don't know the author of it. It's very short. It's a 2-page opinion. The Supreme Court said that's the wrong method. You shouldn't use that method. Now, it did not say precisely how to assess those kind of claims, but it said the Massachusetts court did it wrong. It said, we made clear in Heller that weapons that were not in existence in 1791, they're still protected because common use would mean common use for law-abiding citizens today, not common use only in 1791. In that decision, called Caetano versus Massachusetts, the Supreme Court clearly said that you can't ban weapons just because they didn't exist in 1791. So the argument that you often hear in the public by those in favor of stricter gun laws is, well, how can anything other than a musket be protected if we're doing originalism? And the Supreme Court at least gave its answer to say, well, in the same way that the First Amendment protects speech technologies that didn't exist at the time the First Amendment was ratified, so also weapons that weren't in existence at the time the Second Amendment was ratified are also protected.
It seems like the Massachusetts court was being a little clever. The Supreme Court has suggested that the tradition and the laws that existed at the time of the ratification of the Second Amendment are important to understanding how to regulate guns. So they kind of flipped it and said, well, if the guns didn't exist at that time, then the protection shouldn't apply.
Yeah, I think that's right. I think it was being a little bit too clever because we see the Caetano decision from the Supreme Court, no noted dissents. So even the justices who dissented in Heller and thought Heller was wrong, they didn't dissent in this decision. So all of the justices, at least we don't have the recorded votes, but no justices dissented from that opinion. So seemingly all of the justices said, Massachusetts, you're using the wrong test to apply here. You should be looking at whether or not they're in common use by law-abiding citizens today.
And I guess there's probably an intuitive argument there that, hey, if something way more deadly is a constitutionally protected right, then why not something that's safer?
That's right. Yeah, Justice Alito has a concurrence to that decision, which is much longer than the majority or than the per curiam's 2-page opinion, and he says exactly this: that it would be perverse if you were allowed to say that stun guns are dangerous and unusual, and so can be banned, even though they're much less lethal than what Heller said are protected arms, namely at least handguns in that case.
So what can be banned? What if I want to walk down the street with, you said nunchucks, what if I want to walk down the street with a 5-foot samurai sword here in New York City?
Yeah, this is sort of the million-dollar question. So the Supreme Court has not taken a case squarely about what weapons are protected. That Caetano case was very little reasoning, and all it said was the lower court got it wrong. And so we're seeing now lower courts confronting this question mainly in the context of assault weapon bans. And so the key question with an assault weapon ban that courts are confronting is, are these arms within the meaning of the Second Amendment? So are they in common use by law-abiding citizens, or are they dangerous and unusual, such that they can be regulated in the same way that we regulate machine guns? The government could outlaw machine gun usage because those are dangerous and unusual. And, a constant theme here is we're not seeing a lot of agreement among the lower courts about whether or not these kind of weapons are protected under the Second Amendment, or at least what the historical tradition looks like of regulating these types of weapons. So I think the common use test is the one that most courts have coalesced around. So the common use test gets you protection. So maybe a samurai sword, you might want to have some evidence about how many samurai swords were sold or possessed or how often they're used in criminal activity. But the common use test doesn't answer these sorts of questions about how widespread it has to be. If you show that it's common in one state, is that enough, even if it's not common in others? If you show that it's in common use today, but it wasn't a decade ago or 2 decades ago, is that enough? And what really does it mean to be in common use? Does it have to be used in self-defense incidents? Many gun regulation proponents would say things like high-capacity magazines, people are on average not using 10 shots when they're using a gun in self-defense, and so they say those are not in common use. The response is, well, common use just means commonly possessed, so we own it for self-defense purposes.
So maybe it might be used at a gun range.
Exactly.
Or it might be used, my samurai swords might be used at kids' karate studios.
Sure.
Professor Jake Charles, thanks for joining us today.
Thanks, Joel.